Hello, everybody, and welcome to my live today. What is our subject for today? Well, I'd like to talk about criminal waivers and how you're supposed to prepare them to give you a better chance of success. Okay, and some issues involved with that. I have done, lots of videos on criminal waivers and lots of different subjects, but I'd like to get into a little more detail today about how you actually prepare them. Now, given that, I will afterwards answer all of your questions, whatever they happen to be, as long as, of course, they're on immigration. If you're asking me something unrelated to immigration, I might have trouble answering it. But I'll be happy to answer it, whether you're inside the U.S., outside the U.S., wherever you happen to be, in order to resolve the immigration issue. Now, note that you can put your question here, and then when I'm done telling you about criminal waivers, I'll go back and I'll read whatever questions you wrote and answer at that time. All right, so in regards to criminal waivers, for all intents and purposes, you committed some crime, you can't come into the U.S. because of the crime. What do you do? Okay, so I'm going to assume that number one, the crime makes you inadmissible, and number two, you're eligible for a waiver. Okay, now, just briefly, the waiver is a whole package that goes to immigration. The bottom line, it says, sorry, didn't mean to do what I did. Forgive me and let me in. That's the bottom line. Okay. Of course, it's a little more complicated than that once you put the whole package together. But once you do put the package together, you're able to go on there and hopefully get it approved. And if you do get it approved, the door's open. You can come in to the United States. Okay. So what do you do to prepare a criminal waiver? Well, first things first, you have to put the conviction documents to show what you were convicted of. Don't play around with immigration. Don't say, well, I got it expunged, so I don't need to put that, or, I was only arrested, or whatever it is. You need to come clean. Because immigration loves to make people inadmissible on fraud and misrepresentation, whereas they weren't before they didn't disclose everything. So you're going to be asking for a criminal waiver anyways. So, don't play around by making them guess what exactly you were convicted of and so forth. It doesn't mean, obviously, you have to put the whole criminal file. I mean, who wants to read that? You need to just put what the conviction was, where it occurred, what the sentence was. Okay, I mean, that's it. Okay, and of course, it needs to be certified. Okay, so that's the first thing. The next thing, at least that my firm does, of course, we have a legal brief where we show all of this. Why you qualify for the criminal waiver, why you need a criminal waiver in the first place, and why it should be granted. So what you want to do is you want to assume, you want to look at the law here. The criminal waiver is like a big statue, okay? You have the bad stuff on one side, here's my hand, and you have the good stuff on this side, okay? And you want to minimize the bad stuff without committing misrepresentation or fraud, and you want to maximize the good stuff, okay, without lying or exaggerating as well. And you want to make a coherent argument. So how do you minimize the bad stuff? Well, okay, the bad stuff's the crime, okay? So again, you don't have to put all of the police reports and the statements and the trial transcript and all this other stuff. The conviction, the sentence, and if you're on probation, okay? And then admit to the crime. Just admit to it. So how can you then fill up the other side of the scale, the good side of the scale, to hopefully give the officer, incentive to say yes on granting the waiver. Okay. So you have to look first at rehabilitation. Okay, so what was it that you were convicted of? Was it drugs? Was it abuse? Was it assault? Was it theft? First look at when it occurred. Okay, so hopefully it occurred quite some time ago. Although, if it didn't, there's still arguments that could be made. So you look at when the crime occurred, and then you start making the argument, well, it occurred 20 years ago or 15 years ago. I was kind of dumb and young, and this is what I did, and when all came down to it, it was less than $100, whatever. Which obviously a lot of cases are not like that. A lot of cases are a lot more, okay, and were more recent. But then you can also get into by attaching a declaration of why it might have happened. Okay, I can tell you a lot of people plead guilty because they're in the foreign system here. They have prosecutors that tell them they're going to go to jail for the next 30 years if they don't. All this type of stuff. And so they plead guilty without really doing it. They were just maybe a bystander, or, they weren't the primary person. So, you can do that. Other times people will take the fall because their aunt or uncle is the one that really did it and they don't want to turn them in, some kind of honor code type thing. Other times, the situation of the person was such that their life was really bad at that time, such as, maybe their spouse died or maybe their mother died and have enough to eat, and, whatever it is, they can, put a coherent argument in regards to that. So that's one thing, showing the rehabilitation. Next, try to show family. Okay, show family you have in the U.S. Are you now married? Do you have kids? Do you have parents? Who in your immediate family is a U.S. citizen or lawful permanent resident? You need to show ties to the U.S. And speaking of that, with criminal waivers, there's what's called the qualifying relative. Okay, and a qualifying relative is really what it says. It means that in order to get the criminal waiver granted, you have to have a relative under the law that is related to you in such a manner that will basically suffer hardship if you're not allowed in. Okay, and it differs depending on what kind of criminal waiver you're doing. Okay, so let's just say, your qualifying relative is a spouse. Okay, you have to show all the hardship your spouse is going to suffer if this criminal waiver is not approved. So whereas, as part of your preparation, you can show your economic hardships, your medical hardships, your financial hardships, your educational hardships, all this other stuff that you can show if you don't come in. The qualifying relative, it has to be shown on their end. Okay, so you show all the hardship to your spouse. You show the financial, economic, all of the emotional hardship, everything that can be done. And many times what I will do is I will attach and get a psychological report, for example, the U.S. citizen spouse, to show all of the hardship they're going to suffer and what they might be going under if their spouse is not allowed in. I then bootstrap the hardship, for example, of the kids, because maybe the kids are not allowed as a direct qualifying relative, but at least you can show all the hardship the spouse will suffer if the kids have to be raised by only one parent. Okay? So that's how you can show the qualifying relative and so forth. So you have the rehabilitation, you have the factual, thank you for the rose. You have the factual description of what happened, and you have the hardship reports, economic reports, and so forth. And when the bottom line comes, thank you again, when the bottom line comes, you really want to make the officer cry at the end. Okay. I mean, the bottom line is when they first read the waiver, they're inclined to say no. That's the reality. These officers generally are not dying to give you a waiver. Okay. So you need to, to make it so that they want to say yes. Okay, I have a lot of people who prepare waivers on themselves and they get it denied and they say, I don't understand why I got it denied. I said my spouse was going to suffer and I said that, I filled out the form. Well, that is not enough. Okay, the waiver is more important than the petition itself because you might be doing a marriage petition or a family petition or employment petition, whatever, might have no problems. But unless the waiver is granted, the door to you being able to get in will not work, okay? Will not allow you in. So you have to be able to supplement and have a very strong waiver to convince the officer to say yes. Okay, it's a purely discretionary decision. I mean, you can appeal certain things, okay? Like I'll exaggerate. Let's say the officer says, I do not like people from your country. Nothing personal, but I just don't like people from your country. So I'm going to deny the waiver. I'm not even going to look at the facts. Okay, I know I'm exaggerating here, but there are cases where you can appeal based on abuse of discretion like that. But if you put together a nice, coherent waiver package, then there'll be a lot better chance of success. Okay? So that's that. So now let me scroll back to the beginning of when everybody joined, and then I'll scroll forward to get any questions that might have come. Okay? I hope everybody's doing good today. It is Friday. It's Friday, right? So the end of the week. So everybody has worked hard to get to this point. Take a little relax and watch a live from me. Learn a little bit about immigration. Thanks for the roses for the people who sent. Anyone who wants to send more, feel free. Just a second. Let me scroll down here to get to any questions. 1 second. I still have yet to find a way to easily get to the questions without scrolling through everything. If anybody knows, you can give me a clue. Okay, give me a second. All right, we're getting there. Okay, here's a question. Can a misdemeanor on shoplifting be waived? The answer is yes, if the qualifications are met. Okay, and what are the qualifications? Well, first of all, you need to see if you're inadmissible because of the misdemeanor. Sometimes, depending on the misdemeanor, you're not even inadmissible. Okay, I mean, it's an issue, but you're not legally inadmissible under immigration law. And so assuming that that's the case, you don't even need a waiver. Although, officers, the moment they see a misdemeanor, boom, they're going to deny up and down. So if you're not inadmissible based on the misdemeanor, you're going to have to prepare a legal brief and explanation why it doesn't make you inadmissible. Okay, but assuming it does, then yes, you can definitely get a waiver. But again, you have to determine if you have a qualifying relative. Let's say that you're single, you have no kids, you have no parents here. You're not going to have a qualifying relative to waive the crime unless you're doing for a non-immigrant waiver, in which case, you don't need to have a qualifying relative. So assuming you have the qualifying relative, you have to prepare everything showing their hardship. Now, if the misdemeanor you're talking about is over 15 years old, then you may not even need a qualifying relative in order to get the waiver approved. It's a lot easier. So, for example, if you have this misdemeanor that needs to be waived and it happened 13 and a half years ago or 14 years ago, you might be better served waiting the year to fall under the 15-year or older crimes so that you have a better chance because those are easier to get approved. Okay? So that answers your question. How much time does the USCIS take to make a decision based on RFE regarding the I-864? Well, first of all, you have a lot of initials here, so let me just explain. AOS is adjustment of status. Okay, that's someone who wants to get the green card. based on several different ways. RFE, that's a request for evidence. That's when you submitted something and it's not deniable right off the bat, but then you didn't submit something that is of concern to them. So they send you a request for evidence to give you an opportunity to provide that evidence. The I-864, that deals with affidavit of support. So I suspect you have some kind of family petition, marriage petition maybe, and you didn't provide evidence that the U.S. citizen or lawful permanent resident spouse makes enough money for you not to become a public charge. So you needed to probably submit tax returns or items showing employment or whatever to mandate that they fall under the particular provision so you don't become a public charge. Given that, if everything is properly submitted, it usually takes a few months. Okay. Assuming that you haven't sent it yet, you always want to send an RFE back with proof of delivery. Because immigration, they're not going to go out of their way to say, well, maybe you did get it and we'll check our 300,000 pieces of mail yesterday to see. No, you don't want to do that. You want to send something that has to have a signature and shows who signed it. Okay? Then it's easy. You have proof. So if they pretend they didn't get it, say, well, Joe Blow signed at 3:10 p.m. At this address that it was received. Now, unless Joe Blow is a pretend employee standing there signing for documents that are being sent to immigration, you did get it. And they go, oh, well, okay, sorry. And then they'll go get it. Okay? So look for a few months. If you don't get an answer after then you can do a formal inquiry and ultimately, a writ of mandate where immigration is sued to make the decision. Okay? So that's that. All right, let me scroll more here, see what we got. By the way, if anybody has any questions, now's the time. Okay. I'll tell you what, if you want to do it anonymously, I won't tell your name. Although everyone else can see. Oh, wait, I sometimes I scroll and it goes to the very bottom like it did here. Just a minute. Okay, I think those were the only two questions. Oh, wait, no, here's some more. Wait. I love how sometimes I'm scrolling and it goes up like 14 feet. Okay, hi, we received our NOA last October 7th for K1 visa. What's the next step? Well, it depends if you're referring what you're referring to. If you're referring to notice of action, which you probably are, and there's nothing here saying that it was denied, and it's for the K1, I'm assuming that it was approved at USCIS, and you want to know what happens. From here, it will go formally. Okay, they don't just put it in an envelope. It will go formally to whatever consulate or embassy your fiancé is at which point there a case file will be opened, and then an interview will be set, and also that person will have to sometimes log on to schedule the interview and prepare the Department of State form to be able to come in. Now, hopefully your fiancé is not inadmissible in any way, because it's possible you could still have it approved at USCIS, and then at the interview, the officer might deny it. Okay, that's just a reality. And again, I'll exaggerate to make the point. At the interview, the officer might say, well, how long have you known your fiancé? And the person might say, well, I've only known her for 3 days, but I'm getting married because I want the green card. Stuff like that would definitely get it denied. But normally from the time it is approved at USCIS, from that time until when it goes to the embassy or consulate, depending where it is. Thanks again for the roses. Depending where it is, you look to wait for a few months, okay, for it to happen. It's not going to happen overnight. And then, of course, if it's issued, once your fiance comes in, you have 90 days in which to get married and file the adjustment of status based on the K-1 to get the green card. Okay? All right. Let's see, 10 days after responding to the RFE, I got my work permit. Is that a good sign regarding the RFE? No, that doesn't mean a thing. The work permit is sort of a pro forma thing, okay? Think of the work permit as, once the application's filed, it goes through the processes, and then boom, 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 it issues the work permit regardless. It doesn't matter. The RFE is actually reviewed by a real person, okay? Not that the work permit's not, but the work permit doesn't look at inadmissibility, doesn't look at validity of the petition and so forth. So I wouldn't look at it as a good sign. Don't read into it. Okay, the work permit was issued, period. The RFE needs to be done and needs to be done right. So, it's just coincidence. It was 10 days after. Okay, so don't read into that. I submitted an RFE back in 2023 and yet to receive feedback from USCIS. Okay, there is a problem, most likely. Okay, the fact that it was submitted over a year ago and now, what do we have, 3 more months until it's 2025? You can't keep waiting, okay? I'm sure you probably called and you probably got someone who gave you a typical rogue answer that said, we are processing it. We will get back to you as soon as possible. Okay. And then what that person has done is got you off the line. They don't know what's going on. It's just a typical answer. So I don't know what you did the RFE for, but this is too long. So, assuming you have an approvable case, and if I interviewed you or did a consult in a few minutes, I could tell whether you would have an approvable case or not. You do a formal inquiry. Sometimes just getting an attorney involved in us hopping in is sufficient, because sometimes being immigration, needs motivation, being leverage to move forward. And if they don't have that leverage, they're just going to sit on it forever. And you don't like being in limbo, right? So, the formal inquiry, and then after that, if needed, a writ of mandate to force them to make the decision. Okay? So that's it. Feel free to send me hearts, everybody. I like seeing the numbers go up. It's kind of fun. Okay, let's see. Let me scroll and see if we have any other questions here. Okay, let's see here. Thank you, everyone. I'm 7:30. I applied 12/20/22. I'm still waiting. Is this normal? Okay, so let me again explain what the initials are here, and the numbers. It means that your spouse or your parent applied for asylum, got it, approved it, and now they're trying to bring you in on a dependent asylum application. And it's been over 2 years. So no, that's not normal. It's too long. So I'm not sure if you're from China, but there's no visa waiting time for a dependent asylum application. So I don't know if it's already been denied, or if an RFE was sent and it wasn't answered. You definitely need to do an inquiry to see where it is, because you might do an inquiry and they might say, we sent you an RFE 6 months ago and you didn't respond and therefore we denied it. Okay, I don't know if there's been moving of where the petitioner was and they never received it and so forth. But no, don't keep waiting. You need to do an inquiry. Okay. All right. Wait a minute. Okay. I did my biometrics on June 24th. No EAAD as of yet. So, June 24th. I also responded to an RFE 2023 for tax documents. Okay. Well, if you didn't get your EAD, you probably didn't do it right. Okay. I'm not sure when you filed the application. It's not overly long. I mean, if you're talking about June 24th, 2024, we're talking it's only been about 3 or 4 months. Okay. The normal waiting time for an EAD, at most for an adjustment application would be about 6 months. And that's at the outside max. Okay. But when you say EAD, I could give a 3-hour speech on the different EADs and different situations that they are submitted. So I'm assuming you have some kind of family petition that's been filed and you qualify. But it's only been a few months. So June, July, August, September, October, November, December. So December is the 6 months. So I would do an inquiry in December. Okay. And hopefully you submitted all the documents so there's not an issue with the RFE. Don't link the RFE with the EAD. Okay, they're different. Okay, they have nothing to do with each other. The EAD is just issued when it's issued. The RFE is actually the more important thing, because if that's denied, your whole petition is going to be denied. Okay. Okay. So you're saying he got the green card. Yeah, that might be an issue. This is the person who filed the derivative asylum application and now is, you're waiting on that. The problem here is once someone's granted asylum, they have to wait a year to apply for the green card. Okay. But the way the I-730 works is once they're granted asylum, they have to file the I-730 right away. Okay. If they've got the green card, then that means that immigration might be thinking now that this is no longer a derivative asylee application. I don't know if you're the spouse, but the problem is since he already got his green card, he must have filed the I-730 late. Okay, so if he already got the green card, then that means that he would need to file a petition as a lawful permanent resident for the spouse, of which there's a waiting time on that. At a minimum, the I-730 needs to be within 2 years of when the asylum would have been granted, and it may or may not be outside that. So that might be the very issue of which you're waiting, in that they don't think that it's no longer a derivative asylum application. It should just be a family-based petition based on, lawful permanent residency. Okay. Whoops. Let me see. Let me keep scrolling. Just a minute. Well, you're in the U.S. right now. Well, then it should just be an adjustment application. Okay. Give my office a call. I'll see what we can do. You filed in June 2024. Well, for immigration, that's just like yesterday. So you haven't waited too long. Okay, my work permit got denied twice. Reason 150 days, but I applied for affirmative asylum on February 17, 2024, over 250 days. Well, I think you're finding that the 150 days, okay, this is a person who applied for asylum, and the law says after 150 days, assuming the clock is not stopped, you can apply for asylum, for the EAD. So the question would be, in your case, why did the clock stop? And I can't tell you without giving you a consultation. But obviously, if over 250 days has passed and you still haven't received it, for some reason, immigration thinks the clock has stopped on your case. Okay? And that's why I would need to know. So again, it's not 150 days, no problem, for sure, 100%. Okay? It's 150 days without the clock stopping. Okay. Just a second. Good evening, sir. I am a green card holder. I want to sponsor my children over 21. Can you tell me the time? That all depends what country you're from. Okay. First of all, your kids need to be single, not married. If they're married, they don't qualify. Okay. And I don't know how long you've had the green card, but if you've had it more than 5 years, you might qualify here for citizenship. If you got the green card just recently, I need to know how, but it depends. It really depends what country you're from. If you're coming, for example, from France, you're going to be waiting a whole lot less time than if you're coming from, if you're from the Philippines. Okay. It's just the reality of that. The amount of people coming in from different countries determines the waiting time on family-based preference petitions. So countries like China, India, the Philippines, and Mexico, those are the 4 highest countries, okay, for immigration. So they have the longest waits, okay. Keep in mind also that if your children are college educated, they can, and they may be able to get employment-based petitions faster than you petitioning them. And you can do both. I mean, you can petition them, and then they can still find an employment-based way to come in earlier if they can, okay? Okay, just a second. Hi, I'm in Africa and trying to come to the U.S. by the end of November, but my travel document expiration is on January 14th. Okay, I'm not understanding. If you want to come to the U.S. by the end of November, which is before January, and your travel document expiration is on January, which is, I'm assuming you're talking about next January, you're still good to go. If you're talking about last January, well, then you're going to have to apply for a new visa, okay, if it's already expired. I mean, theoretically, like a passport needs to be good for 6 months past when you enter, but you're not talking about the passport. So unless, you know, you're talking about last January, you still should be able to go, okay? It's still another 2-3 months. Okay, do you think I'm going to have a problem? Well, again, based on what you're saying, it doesn't seem like it, because it's good for at least 2 or 3 months past when you're going to come in, okay? Why the clock gets stopped? Oh, there's all kinds of reasons on asylum the clock gets stopped, okay? Sometimes the judge orders it for various reasons. Sometimes it has to do with what you filed. Sometimes it has to do with decisions that are made, and so forth. I'd have to look at your case more carefully to see why. Okay, I mean, you say you had your fingerprints on time. Well, I mean, it doesn't matter. That's irrelevant. There could be other things. Okay, and the one I just gave said thank you. You're welcome. Okay, well, I think that's gonna do the finish the live out for today. I hope everybody has learned a bit. Go ahead and send me any questions you want after. I'll be happy to give consultations from there. And I had a lot of RFE questions today. Maybe the next live I do will be on RFEs. What do you think? Get in more detail. All right? Well, everybody have a good weekend.